All right, welcome everybody. My name is Mary Claire Ribet. I'm the director of the French American Chamber of Commerce of the Carolinas. And I'm pleased today to introduce William and Meredith, who are going to talk to us about immigration changes under COVID. Lots of changes, and it's very important for all those who have visas or employers who have employees with visas. So thank you very much for doing this for us, William and Meredith. Just wanted to introduce you, Meredith. So Meredith has practiced immigration law since 2006. Prior to becoming an attorney, she was an immigration paralegal. She represents employers and employees in a variety of industries, including but not limited to manufacturing, information technology, medicine, and academia. She has extensive experience in the preparation of non-immigrant visa petitions, as well as extraordinary ability as standing researcher and multinational executive and manager immigrant petitions. She also has significant experience with the PERM process for lawful permanent residents and manages the firm's EB-5 practice. William Hummel has been practicing immigration law since 2012 and is one of a limited number of attorneys certified as a specialist in immigration law by the North Carolina State Bar. Mr. Hummel represents employers, entrepreneurs, and employees in a variety of industries, including but not limited to financial services, education, specialty chemical and biomedical research, and technology. He assists companies and individuals with non-immigrant work visa options, as well as applications for permanent employment certification for professionals and skilled workers and immigrant visa petitions for individuals of extraordinary ability, outstanding researchers, and multinational executives and managers. In addition, he assists clients with global non-US immigration matters. Mr. Hummel also oversees the firm's family-based immigration and citizenship naturalization practice. William is fluent in Spanish and has spent time studying abroad in Spain and Argentina. So just a few rules for this webinar. The attendees can ask questions. There is a question and answer logo at the bottom of your screen. If you want to answer questions, click on that logo and ask the questions. And at the end, I will ask all the questions to our panelists. We do not allow chats or interventions from the attendees because that would be too complicated to manage. Thank you very much, William and Meredith, and you have the screen.
All right, thank you.
Thank you.
You're welcome.
All right, we're going to start sharing our screen. All right.
There we go. All right, as Marie Claire said, we both work for Garfinkel Immigration Law Firm, and this webinar is going to talk primarily about immigration changes in the employment-based immigration world under COVID-19. That's us, our firm. We've got 9 attorneys and more than 35 support staff, so we're one of the largest firms in the Southeast. That's some more information about us. We're in Charlotte, North Carolina. That's a little information about me. Marie Claire did a fantastic job of introducing us, so I don't think I need to go into too much more detail about my background. Or William's. There's
Exactly.
William.
Yeah.
All right. So we're going to talk about current trends and challenges. Just to give you some background on what the climate was like before the COVID-19 pandemic started. In April of 2017, President Trump issued what's called the Buy American, Hire American Executive Order. And that was an order that directed federal agencies and departments to figure out ways to increase employment for U.S. workers and create higher wages. What it really did is, from an immigration perspective, result in stricter adjudication of petitions and applications for folks that were here in the U.S. to change their status or extend their status, and also for initial petitions as well. We saw the Buy American, Hire American effect first on H-1B visas. And it was with a doing away with deference for prior approvals. So the Immigration Service had a longstanding policy that if an extension petition was filed, say for an H-1B extension, and the same parties were involved, the same foreign national, the same employer, the same job was involved, that it would give deference to the fact that a previous H-1B petition was approved in that situation. Now that's no longer the case. Even an extension petition is looked at with fresh eyes. They review all the evidence like it's new. So that's really resulted in a higher increase in requests for evidence after we file an H-1B petition. And we're seeing more requests for evidence across the board in other visa categories now as well. The H-1B is especially getting hit hard on questioning the specialty occupation nature of a job. So the H-1B requires that the job be a specialty occupation, meaning one that requires at least a bachelor's degree. This Buy American, Hire American executive order also resulted in a pre-registration program for new H-1Bs. And that pre-registration just started this year, so we're in the midst of that right now. So far, it seems to be working well, but like I said, we're in the middle of it, so we will have to see how it plays out for this year for H-1Bs. And this is for new H-1Bs, for people that have not had H-1B status in the past. The Buy American, Hire American order also proposed to do away with, or resulted in the proposal to do away with H-4 EADs. So H-4 spouses can get employment authorization documents in some situations. And there has been a proposal to do away with that and no longer allow H-4 spouses to get an EAD. Right now, it's still the case. H-4 spouses can get EADs when they are eligible. And there's no further discussion on when or if that is going to be taken away. So like I said, the Buy American, Hire American executive order resulted in increased scrutiny and denials pretty much across the board. We saw a pretty immediate spike in requests for evidence for H-1B petitions in particular, and for L-1 petitions. Those are both non-immigrant work visas. We're seeing RFEs more now in other non-immigrant work visa categories as well. So there is a increase in RFEs across the board. We're also seeing denials for cases. The rate of denials has increased over the past 2 or 3 years as well. You'll see some statistics there about the decrease in approval rates, meaning increase in denials. And while there's still a majority of approvals, it's a significant decrease in approval rates from 2017. We're also seeing, as far as increased scrutiny, increased site visits to H-1B employers, and now seeing more site visits for employers that have other non-immigrant work visa workers as well. And what that is the Immigration Service can visit an employer after a petition is approved and verify that all the information provided in that petition is accurate and true. Current trends for visa applicants, what we're seeing under this administration prior to the COVID-19 pandemic is enhanced vetting for immigrant visa issuance abroad. So folks that go and apply for their immigrant visa at a U.S. consulate abroad are subject to higher scrutiny than in the past. We're also seeing increased vetting for green card applications in the U.S. The immigrant visa process at the consulate is the last step for folks that are outside of the U.S. to be able to enter the U.S. as green card holders. And then the green card applications in the U.S. are an application process for folks that are already here in the U.S. to get green cards. For those that are outside the U.S., the Department of State has started over the past couple of years to collect additional information for certain visa applicants. So what that consists of is a 15-year travel, employment, and address history that's required, social media platforms and identifiers for anyone who's applying for a visa, and phone numbers and email addresses for the last 5 years. So it's a lot more personal information that the government is asking for and looking into than they have in the past. And all of this has, of course, resulted in longer processing times, both at the consulates for visa applicants and also significantly at the USCIS, U.S. Citizenship and Immigration Service, for petitions and applications that are filed here. So what we're seeing under COVID-19, setting that against the backdrop of what the climate already looks like, as far as the Department of Homeland Security and USCIS goes, USCIS offices have closed in response to the pandemic until at least June the 3rd. So that means no personal interviews are taking place. It was early May, and they backed that up to June the 3rd, so it could be extended for an even longer period of time. Now, the Immigration Service has said that they are going to reuse biometrics that have been previously collected for EAD applications. So individuals that apply for an employment authorization document generally are scheduled for a biometrics appointment at an application support center after filing the application. But due to the COVID-19 outbreak, the Immigration Service has issued notices saying they are going to reuse biometrics if they've already collected those. So they're not making people come in for biometrics, and they're not postponing adjudication of those applications for not having biometrics done. There's also a 60-day grace period now to respond to certain requests and notices. So if, for example, a request for evidence was issued between March 1st and July 1st for a petition filed with the Immigration Service, they are allowing an additional 60-day period to respond to that. Now, they generally give an 87-day period anyway. So it is some additional time. They're realizing that folks are not able to get evidence as quickly as they could before because everyone is working from home. USCIS has always also said that they will have the discretion and could excuse a late filing of a non-immigrant petition if the delay was due to extraordinary circumstances, such as those related to COVID-19. There's always been a discretion for the Immigration Service to allow a late filing, but they are taking into account now issues and situations where COVID-19 is the reason for the delay in not filing a petition on time. But there are no automatic extensions. So just because a filing is late doesn't mean that status is automatically extended or work authorization is automatically extended. The Immigration Service is also accepting copies of original signatures on petitions now. In the past, they've required a wet original signature. Now, because of the COVID-19 pandemic, they are accepting copies of original signatures, not digital signature, but copies of original signatures for petitions and applications that are filed with the Immigration Service.
That's me. So as far as the Department of State, the U.S. Department of State, which operates the consulates around the world, the Department of State has ceased visa and consular functions at consulates, every consulate around the world for the foreseeable future, and there's no official date where the consulates will reopen, and they've not committed to any timeline. There are some exceptions that they've granted for those in important industries such as healthcare workers, agricultural workers. There's also emergency services continue to be available for US citizens. Many of the consulates are still accepting cases electronically to be submitted via electronic format. And some of the consulates our clients are reporting are allowing appointments to be made in the time frame of July and August. And some were even able to get appointments in June, but we're finding that the consulates are canceling appointments in June for the most part. And again, there's no official reopen date, but it can vary consulate to consulate. Some consulates, again, we have a client in Mexico who's able to schedule an appointment in July, but then we have others, for example, in Europe who aren't seeing any appointments available. And so it's a bit hard to predict at this point when the consulates will reopen. And then while not directly related to US immigration, just keeping in mind that there are other restrictions for other countries around the world. I handle, as Marie-Claire mentioned, our firm's global practice. And so while there are the US Department of State, for example, may reopen at some point in the future, applicants have to remember that, especially if they transit through other countries, that there are global immigration restrictions. Just to give you an example, with our two northerly neighbors, the land border between the US and Canada and the US and Mexico is closed. However, for example, flights between the US and Mexico remain available. They're limited, but they're available. And there's no quarantine requirement when traveling to the United States or to Mexico when you're coming to either country. But for example, Canada, there are limited flights that are available, but there is an immediate quarantine requirement in Canada based on Canadian law. So anyone that's been in the United States traveling to Canada has to immediately quarantine for 14 days. And so that's important for everyone to realize, is that even if flights might be available to the US, but if you're transiting, for example, through the Schengen area, there could be quarantine requirements there, or you could be subject to a quarantine requirement because you transit through the Schengen area. And so just keep in mind that even when the US starts to reopen, that there are still global immigration restrictions around the world that we foresee will cause delays moving forward. One thing to touch on is the recent executive order that President Trump issued in late April related to the immigrant visa. The order went into effect on 11/59, April 23rd. And it's the immigration restriction that he had talked about, that he had tweeted about. Now, I will comment that in general, this executive order actually does have a fairly narrow scope. It's not as broad as we thought. The executive order applies to certain foreign nationals seeking entry to the United States for the first time as immigrants, i.e. those who are looking to enter the US as green card holders from day one. So it does not apply to those entering with non-immigrant or temporary work visas. And it does also lay out certain exceptions, and many of the exceptions are the most common people who enter the US with immigrant visas, such as spouses and minor children of US citizens, EB-5 investors, the EB-5 green card category foreign physicians, other healthcare workers, etc. So again, it's pretty narrow. Like I mentioned, it does not apply to non-immigrant visa holders such as H-1Bs, Ls, TNs, and all the other temporary visa categories. It also does not apply to those who already have their green cards, who are already activated and live in the United States, but may have been temporarily abroad. They continue to remain available to travel. This order does also not affect those applying for green cards who are in the United States, who are applying for adjustment of status. Those applications continue to be accepted and processed. It again really is it's a very narrow scope of those applying for their immigrant visa for their green card at a US embassy or consulate abroad who have never had that immigrant visa before. And again, it even has the exception. So we find it's a very narrow scope, but there was a lot of confusion when Trump first announced this order because he made it sound like it would have a much broader application. Now, I will say one of the parts of this executive order did require the Secretary of Homeland Security and the Department of Labor and the Secretary of State to coordinate and within 30 days give recommendations to the president on possible further immigration restrictions. We haven't formally heard what those recommendations will be. There are rumors that one of the recommendations could be, for example, to limit the number of student visas, where students who are working on what's called optional practical training, or OPT, where they get work authorization after graduation. There are rumors that those students who are working after graduation could be targeted, but for the moment, there's nothing official on what further restrictions may come about. As far as Customs and Border Protection, CBP, which is the agency that handles the border, like I mentioned earlier, there is the closing of the northern and southern land border to non-essential travel, to those coming as visitors. And that's the land border, again, not necessarily via flights. Now, there are exceptions. So, for example, those crossing on the land border who already have work visas are allowed to continue to travel back and forth. It's really just visitors. In addition to the land border, there's also the suspension of entry from travelers from certain countries who have had physical presence in China, Iran, and certain European countries, aka the Schengen area, as well as the United Kingdom and Ireland, during the 14 days prior to travel to the US. There are some exceptions to this order, and again, this is separate from the order I just talked about a while ago about the suspension of immigrant visas. This is a separate order that does apply to temporary and permanent visa holders. So for example, someone who has an H-1B or an L visa who is in the Schengen area or in the United Kingdom would be subject to this order. There are some exceptions, again, for those who are spouses of US citizens, healthcare workers, etc. There are also, one thing to keep in mind about this particular order is it only applies to someone if they've been in the area affected. So for example, if they've been in the Schengen area within the 14 days prior to arrival in the United States. And so one idea we've had some of our clients act on recently is that they've traveled to a third country. It's not subject to this order. For example, Mexico. They've traveled to Mexico and they're waiting in Mexico for 14 days before traveling to the United States. So that's something to keep in mind, is that if you are in an area, China, the Schengen area, et cetera, where you are subject to this current restriction, an option would be to travel to a third country, wait there for 14 days, and then travel to the United States. Just keep in mind that the travel ban could be extended further. There's questions. I've heard most recently that perhaps the ban is extended to Brazil, given Brazil's COVID-19 crisis seems to be rising. But that's currently in effect, and that's in effect indefinitely. There's no set end date on that travel ban from Europe and China. I mentioned the suspension of entry for certain immigrants that we just went over from the Department of State, but again, that's very narrow, applies to green card holders in very narrow circumstances. Also, CBP is involved in what's called satisfactory departure requests. Those are for people who are in the US on the visa waiver program, who enter without a visa. Oftentimes they're from Europe, Japan, Korea, for example, are countries that can enter on the visa waiver program. They typically get 90 days of permission to stay in the US after arrival. CBP is granting 30-day extensions if someone is unable to depart the US due to complications from COVID-19. And they're even granting a 30-day extension after that that's available. It is discretionary. If someone is in the US under the visa waiver program here as a visitor and is coming up against their 90-day period, they have to contact the CBP port of entry, a deferred inspection site, and that's most of the major airports. So for example, Charlotte, Atlanta, JFK, Washington, for example, are ports of entry that can grant that 30-day extension. Again, getting the first 30-day extension seems to be pretty straightforward as long as you can show that you can't get a flight back home. Getting a second 30-day period is possible. It's discretionary, but again, you do have to show that you've tried and you've been unable to get a flight back home for whatever reason. Some other considerations, immigration related due to COVID-19. ICE, or Immigration Customs Enforcement, has temporarily relaxed I-9 requirements. ICE is the Immigration Enforcement Agency. They handle, one of their enforcement protocols is for the I-9 requirement. Typically for the I-9, the employee has to provide original documents to begin work for work authorization purposes. Right now, if you are letting employees work remotely, and including letting employees start work remotely, they can provide copies of documentation digitally to the employer. The employer should make a copy of it, and then keep in mind to request the originals once you return to the office. But they are allowing for copies of documentation right now for I-9 purposes. They're also extending the E-Verify timeframes that is required, again, for documentation purposes. So they are being fairly relaxing, and that's automatic. There's no need to request those extensions. Those are automatic. And they've given really good guidance on how to complete the I-9, how to annotate it, and same with E-Verify. One thing we're seeing related to many of our clients have had questions recently about furloughs and possible effects on visa status, both furloughs as far as pay reduction, but also not paying at all. And there are a number of different factors that come in when you're looking at furlough, both the visa status, whether it's a pay reduction or a pay halt entirely. That gets very specific oftentimes on the unique situation, but it is something to keep in mind that if you do have workers, or if you're someone who's on a temporary visa and you are being furloughed, to reach out to your immigration attorney to discuss your situation on what that means, what it could mean for your visa status. Also, there's questions about eligibility for unemployment and whether someone on a temporary work visa is eligible for unemployment. In general, unemployment varies state to state. It's determined by state law. For example, in North Carolina, in a general sense, you do have to show you have the ability to work for any employer, which can be a problem for non-immigrant visa holders because you are not generally authorized to work for any employer. You're restricted in employment. So there could be questions of eligibility for unemployment, whether, especially again in North Carolina, someone may not be eligible for unemployment. Also, again, there's the question of furlough versus layoff. We've had clients that want to furlough the employee, they haven't terminated them, they keep them on benefits versus laying off. If it's a true termination, that has effect both on the employee situation as they no longer have their visa status if they've been truly laid off, but that also can have impact on the employer for those employers who are sponsoring employees in the green card process. Layoffs can have effect on the green card process, the perm process. So that's something to keep in mind too, is to keep your immigration attorney, your counsel updated for furloughs and layoffs and the distinction between the two. Also, remote work, as probably many of you all are working remotely, and generally we are as well. Some work visas are location, including address specific, especially the H-1B. And any change in work location, even if it's from working in the office to working in their apartment down the street, could require action. And it could be something as simple as posting a notice in the employee's home that a work site has changed. But if the work site location has changed significantly, and if an employee, for example, moved from North Carolina to Michigan to be with family during this time, but they're working remotely. That could require an amendment or a filing with USCIS. So again, that's something that if you do have employees that have begun working remotely, to reach out to your immigration counsel to discuss whether any action's needed. Again, some work visas aren't worksite specific and it's not a big deal, but others are worksite specific and address specific and requires action. Lastly, the further action, again, there's questions of whether President Trump will take further executive action. Like I mentioned, the Secretaries of Labor, Homeland Security, and Department of State are supposed to come up with recommendations. There's lots of rumors about what that could be. It could be nothing, but given the state of the economy, there are some calling for further restrictions in immigrations, further restrictions in temporary work visas in particular. And so we'll have to see if an executive order is issued, what that entails, how far it goes. And then, of course, there's also the question of will it be challenged, which it likely will. Many of President Trump's executive orders have been challenged or are being challenged. So I think any executive action that's issued by President Trump in the weeks or months to come will also be challenged. And then there's the question of whether it will be enjoined by court and how long that litigation drags on.
Lots to happen.
Yeah. So that's a very broad overview of the COVID-19 situation with immigration. At this point, I know we want to open up to questions, and I think there were some questions in the Q&A box. So Marie-Claire, I don't know if you want to
read those.
Yes, there were some questions. So the first question is, if the USCIS offices are closed till June 3rd, will this affect the lead time for the EAD approval and card issuance of August 2020 graduates?
Yeah, the closure of the USCIS offices, generally we've still been seeing EAD approvals come through. It's been for folks that already have biometrics on file. So it remains to be seen whether or not it's going to delay applications where folks do have to have biometrics and haven't had that before. But we are seeing approvals of the EAD applications.
All right, well, thank you. Second question the first question was by Pius Gujarat, and the second question is from Mr. Philippe Legris, who, by the way, is also the president of the French-American Chamber of Commerce. What are the conditions for an L1 visa holder to re-enter the US currently?
And I guess that question would depend where you're coming from. But for example, if you were in France, let's say you were home in France, you were in the Schengen area. Right now, an L1 visa holder, if you have a current visa, you don't need to go back to the embassy, so that's good because the embassies are closed. But if you've been in the Schengen area, for example, you are not allowed to come to the United States unless you fall into one of those exceptions, which are, for example, spouse of a U.S. citizen, healthcare worker, etc. If you've been in France within the 14 days before arrival. But, for example, an L1 visa holder who's been in France, if you could travel to Mexico, sit there for 14 days, and then you'd be allowed to travel to the United States after that 14-day period, that could be an option. Some of our clients have asked about Canada. Canada could be an option, but the problem is Canada has its own quarantine as well. Mexico does not currently have the quarantine. So Canada could be an option, but just keep in mind, Canada, you will be immediately quarantined in Canada, so you won't be able to do anything in Canada yourself. If you're in Mexico, at least you could, perhaps sit on the beach somewhere, or go to a restaurant. But you do have to wait in a country for 14 days, and then you'd be allowed to come to the US on your L1 visa. So there is a way to get around it, but again, it would involve waiting in a third country for 14 days at least. Now, if you are coming directly, let's say from Mexico, you're an L1 visa holder, and you've been in Mexico for the last couple weeks, you can come to the US. It's just a matter of booking the flight.
Yep. And I think that answers the next question.
Yeah.
Now, could you be more precise then? I mean, I'm curious about what if you take a plane? So you cannot basically take a plane from France, for example, because a lot of our people listening are from France, and come into the US. They will stop you at the border.
Right.
What happens exactly?
Yeah, the airlines actually won't even let you on. Our understanding is the airlines, unless you showed, for example, you're married to a US citizen or you are a green card holder, the airline will not let you on. They will not. And so then it's a question again of finding that flight to Mexico, to Canada, to somewhere else, to temporarily. But it's the airline. It's actually the airlines right now that are enforcing that for immigration. And our understanding is that they're being very strict. Sometimes I've heard they're overly strict. They're they're not even letting people who should be allowed in, for example, who have spouses that are US citizens, but it's the airlines themselves that are screening that and deciding who can get on the plane.
Do you have any idea, for example, someone who has booked a flight like months ago, because often they do that, people do that because it's cheaper if you do it 6 months before your departure. So you have you have a flight to France or to somewhere in the Schengen area and the flight back, and so they will not allow you to use that flight. Would they maybe allow you to use the flight to go to Mexico instead? I mean, have you heard of any situations like that?
I mean, I know anecdotally the airlines are being more relaxed with, changing travel and fees. So that's definitely a question to I think it's airline specific.
Yeah.
But I would hope, to certainly apply some of your costs that you've paid to fly to Mexico, for example.
Mm-hmm. All right. I have another question from anonymous attendee. As the spouse of a US citizen living in Europe now, I understand I am part of the exceptions to enter the US. Would I be eligible to get a job?
In general, yes, you have to have the appropriate work document, whether that's a green card or a temporary work visa. But if you had a green card or your temporary work visa, you were exempt from the ban, and you'd be allowed to get on a flight, come to the US and begin work. But you would still need that work authorization document, whatever that is.
Yeah, and for the moment, that's not easy to get, I'm sure.
Right. And if you don't have one, to the point, if you don't currently have a visa or a green card, you're not subject to the travel ban, but the problem is the embassy in Paris, for example, is closed. And so there's no way to get in to get your visa stamp.
So, but let me clarify that. So this person married to an American citizen, would they would be allowed to come in, but then, I mean, what the situation in the US? Aren't they supposed to stay for a certain amount of time until they have proper documents?
Right.
Normally, so.
Right, yeah, you may be able to come as a visitor, but that doesn't give them work authorization, so then it's a question of
temporary period to stay as well.
So it's a 3-month period, basically. All right. Okay, thank you. I myself have a question for students. I mean, I've heard that, I mean, you mentioned that the students who have a J1 visa or an F1 visa will probably not be able to get to the embassy. So the students who are already currently studying and not particularly being graduates, if they go to France for the summer, they might not be able to come back.
Right. That's a good, right now, we don't know when this travel ban will end. And so it's a possibility that someone returns home for the summer and able to return back in time for fall semester. I mean, I know a lot of universities are making plans for this very issue. Yeah. But you're right, Marie-Claire, that there could be someone who goes home and isn't able to come back in time for fall classes.
So it might be a good idea not to leave for the summer.
Right.
Just stay here. Just stay put, and just in case. Okay. I don't think there is another question for the moment. Could you think about other points that you wanted to make, maybe?
Yeah. I mean, and someone asked a question about reaching out for advising on OPT and H-1B. Absolutely feel free to reach out to either one of us. Our contact information is there.
Yep.
Yes.
We're happy to talk with employers about the situation and whether action is needed. And then I see one more question. Where can I go by plane to renew my I-94? I think that ends up being very situation specific. So that person might feel free to reach out to us and we can advise. There are some of the borders, for example, Canada and Mexico are allowing I-94 extensions if you contact them ahead of time.
Right.
But otherwise you may have to file with USCIS as well. So for that person, feel free to reach out to us and we can advise on the situation.
Yeah, you could still file extensions with the Immigration Service. So I know a lot of people on certain types of visas in the past have just traveled to get a new I-94 and get an extension that way. But if they can't travel, they can still file an extension with the Immigration Service.
Okay, all right. I have one last question, but you maybe have already answered, but I have some people in the French community, because I'm also the honorary consul, who had deaths in their families and they had to travel, to France for the funeral. And these people would have, again, same thing, they would have to be unless they're US citizens. They would have to transit through Mexico to come back here or another country.
Right.
Wow.
Yeah, there is a discretionary, and we've had some clients, there is in the travel ban, there is some rather vague wording. It says otherwise in the interest of the United States, and there's a question of, well, how do you document that your return would be in the interest of the United States? And to your point, Marie Claire, I think sympathetically that person, didn't leave, they didn't want to leave, they had to leave due to a unique
Exactly.
situation. But
Yeah,
it's unclear how you get that permission to come back, because you can't request it from the embassy. The airline can't really grant it, but they're the ones controlling, the getting on the airplane. And it's unclear even to us, who in the United States do you get that permission from? Do you get it from the airport? Do you get it from immigration?
Right.
And that's a question a lot of attorneys we know are asking that same question. It's someone who has very sympathetic, unique circumstances, but they don't fall under one of the other clear guidelines.
exactly.
How do we request that permission? And there's no good answer.
Right. Yeah.
Okay. Well, that's very interesting, because at the moment I had 4 people who had to travel to France for a funeral, like parents and brothers-in-law. So I mean, I'm sure they want to come back because they all have a job here.
Right.
Yeah. Okay. All right. Well, thank you very much, both of you. That was very interesting and very informative. To all the attendees, we are recording this webinar, and it will be available. We will send it to all the attendees via email, and also if you provided your email. And if not, you will see it on our website, and probably also you'll see the link on our next newsletter. So look for the link on the website in the next days. Thank you very much, William and Meredith. It was a great webinar. Thank you. Have a great day. And thank you for all the attendees.
All right, bye-bye.
Thank you. Bye-bye.
Bye.
Questions now?